Next up is third-party litigation financing, the role of disclosure and the judicial role. I know that you've already talked about this in a number of other panels, but I think we have 4 fresh perspectives on this that will take us into an even deeper discussion on these issues. And we are honored and delighted to have Judge Chad Readler here to lead us in this panel. Judge Readler is a judge on the U.S. Court of Appeals for the Sixth Circuit. Prior to joining the Sixth Circuit in 2019, he was a clerk for Judge Alan Norris on the Sixth Circuit, then worked in private practice, and then was the Assistant Attorney General for the Civil Division of the United States Department of Justice. And then took his role on the bench. And so we are delighted to have Judge Readler to lead us through this discussion of third-party litigation financing, the role of disclosure, and the judicial role. Judge Readler.
Thank you, Donald. Donald, you're doing such a great job with these programs. Thank you for having us. I attribute most of your success to the fact that you were also a former Sixth Circuit clerk. So it's great to be in such esteemed company. So our topic this morning is third-party litigation financing. That might be ringing some bells in your head after yesterday. In some ways, it sort of reminds me of the famous quote in politics that, quote, everything has been said, but not everyone has said it. But I assure you that that won't be the case this morning for 2 reasons. One, our perspective is going to be narrower. We're going to try to talk mostly about disclosure and the role that all of you as judges should be playing in refereeing these matters. And 2, we have 4 really terrific speakers who know these issues quite well. So I think we'll all learn a few new things this morning. And like all the other panels, I hope we'll have some questions at the end. So I will introduce the speakers as they are going to speak. Each will speak for 10 minutes or so, then we'll go back and forth, and then we'll take some questions. So we're going to start at the end of the table and move across. Our first speaker is Professor Maya Steinitz. Professor Steinitz teaches civil procedure, international arbitration, international business transactions, and corporations at Boston University School of Law. Her articles have been published by leading law reviews, the Yale Law Journal, at Yale Law School, Harvard Law School, and Stanford Law School. I think it was mentioned yesterday during our keynote that she appeared on 60 Minutes last year. She's previously been a lecturer at Columbia Law School, and she's worked in private practice, and she served as a clerk on the Israeli Supreme Court. And although it's not specifically relevant to today's discussion, I found it very interesting in her bio that while in private practice, Professor Steinitz represented the emerging government of South Sudan in drafting its national and subnational constitutions and provided legal advice on various aspects of the Sudanese peace process. So I'd love to ask you about that, but maybe we'll start with our topic today, which is third-party litigation financing.
Yeah, thank you very much. Hopefully I'll say some new things on an issue slightly less contentious than War and Peace. Thank you for inviting me to speak on this very important topic. Where I'm going to take us, where I'm going to end up, is I'm going to suggest that it's critical for judges to take an active role in supervising litigation funding, and that we need sort of managerial judging entering into this topic. But the way I'm going to get there is I'm going to first talk about the financialization of litigation and explain what I mean by that. So sort of like what are the recent developments in this area. Then I'm going to talk a little bit about what are the effects, or why should we care that litigation is being financialized. And then I'm going to talk a little bit about managerial judging. By the financialization of litigation, I mean predominantly that increasingly what we're seeing in the area of third-party funding is the use of portfolios. I'll explain what that is in a minute. And more secondary markets in legal claims, and I'll explain that as well. But before I go into that, I just want to say a couple of things that you know, but it's important to keep those in the forefront of our minds. So one is that what litigation funders are obligated to do, as all funders and as all for-profit entities under our corporate law, is to maximize profit for their own shareholders. Corporate law doesn't allow for-profit entities, those who are running them, to do anything other than maximize profit. So that's what they need to do, and it's appropriate that they do that. But what that means is that any positive social effects like access to justice, which is one of the beneficial effects of litigation funding, is what we call a positive externality. It's not the goal of for-profit litigation funding. And the other thing is that unlike the other two types of actors that traditionally were allowed funding litigation, which were lawyers and insurers, funders don't have fiduciary obligations. So we have actors that must maximize profit and have no fiduciary obligations. And increasingly, they are operating through by creating or investing in portfolios of cases that have secondary markets. So what does that mean? Portfolios is a funding modality whereby funders invest in cases that are aggregated, they're bundled together. When funding first emerged, funders funded single cases by contracting directly with the client. That funding still exists and it will always exist, but increasingly what's much more profitable and beneficial for a variety of reasons for funders and lawyers is to bundle cases together as portfolios. What that does, among other things, is it increases conflicts of interest. Because what I propose that, I propose we think about portfolios of cases is that portfolios are a form of economic aggregation. It's an economic aggregation device. So we have procedural aggregation, right? We have class actions, MDLs, derivative action, and arguably bankruptcy is increasingly kind of an alternative to the MDL. It's a form of aggregation. And those are, when we have those kinds of aggregation, courts actively supervise because we understand that the aggregation creates conflicts of interest between the different claimants in the different cases, right? They have conflicts amongst each other. The lawyers have conflicts with their clients. And now we also have funders who have conflicts with the claimants and with the lawyers. Sometimes the interests are aligned, right? Sometimes everybody just wants to maximize the award or the settlement, right? And that's great. But sometimes the interests are not aligned. For example, when the plaintiff wants non-monetary relief, right? The funder has no use of non-monetary relief, and that's fine. They're for-profit entities. But conflicts are structural, and portfolios increase conflicts. Secondary markets is just the idea that we have sort of lawyers, funders, and other entities that are increasingly springing up that originate and bundle cases, but they don't necessarily hold on to the cases. So different, again, players in the marketplace are originating cases, and then they're selling it down the stream. They're not necessarily keeping a stake. They don't have skin in the game. And what that does is, just like we saw we were familiar from other types of asset classes, is when someone originates an asset but then doesn't hold on to it, and especially when those assets are bundled together, then there's what we call a moral hazard, namely there's whoever's originating the case has no interest in properly vetting that the cases are actually good cases. So we saw this famously in the case of mortgages, right? So when you have sort of people who are originating, but they're not holding on to the claim, they're making a profit as soon as they originate and sell it on to, say, a law firm or a funder, and then those bundle the cases together, then you really have structural incentive also to bring non-meritorious cases together with meritorious cases. That wasn't true, and it's not true in the original model where a funder funds an individual case. When a funder funds an individual case, there's generally speaking no money to be made if the case isn't good, because if it's not good, then there's just, why would anybody give you a high settlement? But when you bundle cases together, then sometimes just by increasing the size of the portfolio and taking good cases together with bad cases, there's value to be had by just increasing the size of a portfolio of good cases with bad cases. And by the way, I've heard this in the past couple of years from, among other things, from funders who are saying, we want better vetted portfolios, but we're faced with some lawyers who are saying, look, if you want this portfolio, it's a take it or leave it deal. You have to take the entire portfolio. You can't cherry pick the good cases. So that's increasingly the environment we're in. So I don't want to say that all cases are bad. I hope that it's clear from what I'm saying is that it's complicated, right? There's good cases that get access to justice through funding, but there's structural incentives increasingly to bundle them together with not good cases. And then there's additional incentives that are created through portfolios. So what else is happening? Well, once you have a portfolio, then the economic incentive is to increase the value of the portfolio as a whole, not necessarily of an individual case. What does that mean? Well, it sometimes means that the value of a portfolio is increased by extending the life of an individual case that would otherwise settle. And one case became publicly very famous, the Cisco-Burford litigation. I was an expert witness for Cisco in that case, where Cisco and its defendants were interested in settling the case, but they were compelled to continue litigating it for the benefit of a funder who believed that if the case continues being litigated, that would be beneficial for the value of the portfolio as a whole. Right, so right now, we're in a new world in which, again, we have economic aggregation of cases, not just procedural aggregation, and that's affecting the trajectory of cases, and it's affecting the system, because cases may get extended, and there may be conflicts of interest. Now, this form of aggregation, unlike procedural aggregation, by and large, is invisible to the courts. It's often invisible to the defendants. It sometimes is invisible to the plaintiffs. Plaintiffs don't necessarily know, say in a class action setting, that their cases is being funded. They may not know that their cases, even in a non-class action situation, that their cases have been bundled by the law firm with other cases. So clients don't necessarily know what are the incentives behind the scenes that may be prolonging their cases or that may be leading for their lawyers to recommend or seek monetary relief as opposed to non-monetary relief, right? And that affects individual cases, and it affects the system as a whole. It affects defendants' due process rights. It affects the integrity of the judicial system. So where does that lead us? I think where that leads us is that we need to deal with what I call economic aggregation the same way we deal with procedural aggregation. So portfolios need to be understood the same way we understand procedural aggregation. Class MDL's derivative, which is that we have to have judges look under the hood and take an active role, especially in situations where there's questions arising as to who's controlling settlement decisions. In class actions, there may be questions of who's selecting the lawyers, why are they selecting these lawyers, and there may be other issues as well. I'll point in your direction. By the way, if you're interested in this, there's a forthcoming paper that I provided as part of this symposium. You should have access to it. It's called Zombie Litigation, and it's forthcoming in the Cornell Law Review. So all of this is fleshed out in more details. But a couple of examples of steps in that direction of managerial and even inquisitorial judging applied to economic aggregation is Judge Rogers' role in the 3M litigation, where she asked lawyers to disclose whether any third parties are taking control, and also placed some limitations on any sort of potentially abusive pricing of the funding. And Judge Connolly in Delaware, who believed he saw red flags of fraud on the courts and what he believed to be potentially very serious abuses of process, and he actually conducted an investigation and ended up making referrals both to bar associations and to the Department of Justice. So that's sort of an outlier case, but those are examples of judges who are taking an active role. So I've met my 12-minute limit, so I'll stop here.
Thank you very much, Professor. Next up is Alex Dahl. Alex is the founder and CEO of Strategic Policy Counsel and serves as outside general counsel to Lawyers for Civil Justice, a national coalition of corporations, law firms, and defense lawyer organizations. He advocates for the corporate and defense bar to secure the just, speedy, and inexpensive determination of civil cases, including the 2015 amendments to the federal civil rules addressing critical discovery issues. Alex has served in all three branches of the federal government as counsel to the Senate Judiciary Committee, working for then Chairman Orrin Hatch, as a federal prosecutor in the U.S. Attorney's Office in Washington, D.C., and as a law clerk to a federal district court judge. He's also worked in private practice as a lobbyist and a civil litigator. The question I want to ask is, having worked in all three branches, which one stood out to you between the three? But I'll let you use your time how you want.
Well, for this audience, it's the judiciary, of course. I want to pick up right where Maya left off with the different approaches judges are taking to TPLF. I think we have seen in the last couple of years a real sea change in response by the judiciary, because a couple years ago, it seemed that judges would fairly confidently say, I've never had third-party funding in any of my cases. And now I think there's a realization that, in all likelihood, you have had third-party funding in your cases, and there's a realization that there are questions to be asked, and judges are undertaking to do that. At very least, they want to know who is in control of the litigation and who is directly benefiting from the judgment of the court. The problem today is that courts are doing this in a variety of different ways, inconsistent over the country, and also in some inadequate ways. Lawyers for Civil Justice is advocating for disclosure rules because we believe that courts and parties need to know who's in control and benefits from litigation, and that disclosure ought to be on the basis of simple, uniform rules that are understandable and clear and predictable. Judges shouldn't have to reinvent the process for TPLF disclosure case by case and court to court, and shouldn't have to write 100-page opinions, as we discussed last night at the final session. In the meantime, while people are working on rules, courts should ask about TPLF, and that is the name of Lawyers for Civil Justice's new initiative, in part because several of the existing rules actually require courts to know about TPLF without providing that information. So why should courts ask? Well, a trial court should know who the decision makers are in a case in order to manage the litigation. One example that I'm sure a lot of you are familiar with is requiring the presence of decision makers at key parts of the litigation, including settlement conferences. And this is an idea that yesterday on this stand a funder agreed to, that that's a very important role for the court to have. The current rules, as I mentioned, actually require judges to know if there's a non-party in control and benefiting from the case. Let me give you some examples. Rule 26B1's definition of the scope of discovery contemplates that judges understand, quote, the resources of the parties in making a determination about whether a particular discovery request is proportional to the case. Well, you don't know the resources of the parties without knowing that one of them is being sponsored by a wealthy hedge fund or some other funder. Similarly, allocating costs in discovery or imposing sanctions when necessary requires knowledge of who's making decisions and who's benefiting from that and what their financial situation is. Federal Rule of Evidence 607 gives parties the right to question the credibility of a witness, and part of the questioning the credibility is whether that person has a direct interest in the outcome of the case or is being paid by someone who does. Well, if you don't know that there's a third-party funder in your case, how can you possibly have the right to ask the witness whether they're being paid by someone who's making the decisions or stands to benefit from the case, or even have an interest in the outcome of the case? In class actions, the rules are even clearer. It's a judge's duty under Rule 23 to make sure that, that the representation is fair, and also that the settlement is fair, reasonable, and adequate to class members. How could you possibly rule on whether a settlement is fair to class members without knowing that by contract, the lawyers have given away a third or a fourth or a half or whatever it is of the proceeds to somebody else who's not a party to the case? Only in the Northern District of California can you find that out. By local rule, they require that in class action cases, lawyers have to reveal whether they have given the right to the proceeds of the case to somebody who's not a party to the case. And conflicts. Judges, of course, are required by statutes and ethics rules to recuse when they know that they have a financial interest that can pose a conflict. Now, TPLF used to be an obscure financial industry, and it seemed very remote that a judge could possibly have a conflict. But the biggest public funder in the country issued a report this week where they claim that 82% of law firm lawyers say that they use legal finance. And TPLF exists independently at the appellate level as well. Parties have a right to rebut, and judges a duty to manage, a plaintiff's characterization of a case as a David versus Goliath situation. Courts have allowed information about TPLF disclosure in this situation. When either the court or the parties are unaware that the TPLF agreement provides significant resources to the party claiming to be the David in such a case, neither the party or the court can give meaning to this right. This is an example where TPLF secrecy is being used not as a shield to protect any sort of interest, but rather as a sword, as a tool for litigation. And finally, and this gets to the nub of a lot of this, when courts and parties don't know who stands to benefit directly from the operation of the court's judgment, courts cannot administer, and parties do not have the protection of FRCP 17A1, which requires that an action must be prosecuted in the name of the real party in interest. So those are some of the reasons why courts need to know. In addition, parties need to know. And it has been part of the civil justice system since the founding, before the founding of our country, that parties have the right to know who brings them into court. A neighbor who gets sued for tree roots or whatever should know that it's not actually their neighbor suing them, but it's a hedge fund or it's somebody who hates them for some other reason. And it has been contrary to our legal tradition to allow people who don't have standing to make the control decisions and to prosecute litigation against people without the knowledge of the court or the party. There is also a right to know if the named party actually has the power to settle the case. This is the settlement problem. In a recent letter to the Federal Civil Rules Advisory Committee, 124 companies said, the settlement process often unravels when the nominal plaintiff or its counsel needs to obtain approval from an undisclosed non-party funder or uses the non-party as an excuse to retract a commitment to settle. Now, this is the exact same reason that courts often require somebody from the insurance company with actual decision-making authority to attend settlement discussions or other key moments in the litigation. And speaking of insurance, the Advisory Committee on Civil Rules explained in 1970 that the reason why they were going to start requiring disclosure of insurance agreements is this, that it will enable counsel from both sides to make the same realistic appraisal of the case so that settlement and litigation strategy are based on knowledge and not speculation. The same exact point applies to third-party litigation funding. I'll throw in one more, which has to do with the public right to know. In America in particular, courts are public, and the members of the public have a right to know who is using their courts and for what. So, how should courts go about asking about TPLF? As I mentioned, there are many different experiments going on because courts are doing this in different ways across the country at different stages in litigation. But there's really only one answer in our adversary system. Require the disclosure of the agreements and let the parties brief the court and explain what, if needed, what needs to be decided or what is okay and what is not. The fact is that these contracts can be very complex. They're very likely to contain boilerplate language disclaiming any sort of control, but they still contain provisions that give control to the funders. One notable case turned on the language in the contract that said consent to settlement will not be unreasonably withheld. That may not jump off the page as a control feature, but that turned out to be a veto against the named party's ability to settle the case. As 124 companies said in their letter to the advisory committee, we cannot understand the control features of a TPLF agreement without reading the agreement. If TPLF agreements are disclosed, there will probably not be problems in every case, but that's the only way to know. And importantly, it's also the only way that our judicial system is ever going to develop case law about what these contracts mean and what's okay and what's not, particularly in the element of control. The control features such as the funding that occurs in tranches at key states of the litigation exercise control, and somebody needs to look at them. And in our adversary process, what that means is that the parties should have equal access to the information and bring issues to the court. The experiments that are going on have also shown the wrong way to ask about TPLF. And the wrong way is ex parte. Ex parte conversations have a role in our judicial system, but that role is not the routine procedural mechanism for determining the meaning of contractual language that may affect all the parties to a case. The Code of Conduct for U.S. judges generally prohibits ex parte communications. And it further states that when judges do receive ex parte communications on a substantive matter, they should, quote, promptly notify the parties of the subject matter of the communication and allow the parties the opportunity to respond. The exceptions are when circumstances require, including scheduling, administrative, or emergency purposes. A court's effort to understand the control features of a TPLF contract do not fall within these exceptions to the general ban on ex parte communications. The fact is that any procedure that excludes the parties is inadequate. It allows a judge essentially to figure out the meaning of a contract that could affect everybody in the litigation, make a legal ruling without the benefit of the parties, and it's risky. I mean, what if a court reads the contract, concludes there's not any control feature here that gives me any trouble, and yet that very legal point becomes the subject of arbitration or parallel litigation in that case, where the parties are, undergo an entire judicial process to see what that contract means and why they acted in the way that they did. And all this time, a court is in the position of having read the agreement and talked about it with one of the parties without disclosing their analysis or opinion or anything else to the other parties that are affected by the contract. The bottom line of this is that there are lots of reasons why courts and parties need to know about third-party litigation funding, and courts should handle it in the normal way that they handle everything else. Disclose to the parties. If there are issues, they should be briefed and teed up for decision. The sky will not fall if this is the procedure that is used. And the sunlight will help. It will help courts, it will help parties, and frankly, it will help the legitimate players in the financing industry who are constantly having to defend some of the bad acts that all of us agree are egregious examples of things that should not be happening in our system. Thank you.
Great, thank you, Alex. Next up is James Burnham. James is the president and founder of Vallecito Capital, a litigation investment fund. Before founding Vallecito Capital, James was a litigation partner at Jones Day, a senior official in the Department of Justice's Civil Division and the Office of the Attorney General, and a senior associate counsel to the president. And since disclosure is one of our themes today, I'll disclose that I worked with James in most of those positions. Sadly, I don't have any interest in his current, more lucrative endeavors, but I will be as fair as I can be. James,
It's not as easy as they make it sound.
James clerked for Justice Neil Gorsuch on the U.S. Supreme Court, and before that on the Ninth Circuit Court of Appeals. And with some relevance to our gathering today, James is a gubernatorial appointee to the Gunston Hall Board of Visitors.
Go visit George Mason, really cool.
Yes,
Kinda
Gunston
far.
Hall being a mansion on the Potomac built by our host's namesake, George Mason. James.
Thanks, Judge. And thanks to Scalia Law for organizing this terrific panel. I'm always happy to debate three people at once. Hopefully the moderator will stay out of it. So look, as Judge Readler just explained, my background as a lawyer is in public law. I spent basically my whole career until a year and a half ago doing litigation against the government for injunctions, declaratory judgments, things like that, or at the Justice Department on behalf of the government defending, whatever it is the government wanted to do. And so that's kind of my framework for thinking about all of this. I started the fund a year and a half ago. It's unique in the sense that, I think the professor was talking about positive externalities and funders not caring about that stuff because they can't. We are different. Our fund is actually trying to blend public interest law style litigation with for-profit litigation finance. So I actually care quite a bit about the positive externalities of the case. In fact, that's kind of the point of the case. We're just seeing if we can also get investors their capital back plus maybe a return while they fund litigation that also makes the world and the country better off. Anyway, so in the purely public interest space, litigation finance has been around for a really long time. It's been around forever, or for as long as we've had public interest litigation. The ACLU, the Pacific Legal Foundation, my dear friends at the U.S. Chamber of Commerce Litigation Center, those are all litigation finance funds. Those are nonprofits, they have no revenue. People give them money, and they use the money to file lawsuits. The motivations and goals of the people who give them the money are totally unknown. Their identity is usually unknown, and we have no idea why they've given money to, say, the U.S. Chamber Litigation Center to challenge a particular federal regulation or rule. Now, when I was at the Justice Department, I defended a lot of cases filed by these sorts of organizations, and it never even occurred to me that I should be worried about, who the donor was, who's behind the ACLU in this case. Why are they suing over the border wall? It just didn't have anything to do with the merits, and it seemed to me that if I went after them and said, who donated, was it this guy, whoever, it would just be distracting, it would be harassing, and it would be kind of beside the point. The judge doesn't care. My view was the judge doesn't care who the donor is. The judge cares about whether the government has the authority to do the thing that we want to do. And if we do, we should tell them that or her that. We should not, fight about who's paying the ACLU's legal fees. And so from my perspective, the investment product that we call litigation finance is basically indistinguishable in most respects from what I just described. And I think it provides an equally obvious benefit to the legal system. So let me get in a little more to the merits. So look, as we all know, defendants, particularly large corporate defendants, almost always have more resources than the plaintiffs, right? Unless it's a company-on-company litigation. That's why we have we have long allowed contingent fees. Okay, contingent fees are just litigation finance. The contingent fees are the lawyer making a loan to the plaintiff through the lawyer's work in expectation of a payout at the end if the case hits. And it's a way for people who've suffered legal wrongs to get really good lawyers to help them. We've heard a little bit this morning about how scary it is that people are trying to profit maximize litigation. Guys, contingent fee lawyers are obviously trying to maximize their contingent fee in a way that is, of course, consistent with their ethical obligations to the clients. But the idea that this is some, crazy new phenomenon is absurd to me. Oh, and by the way, the defense firms, of course, are trying to maximize their profits too. They all fight every year for who can be number one in the Am Law ranking of most profitable law firms. So the idea that the people who've occupied the field pre-litigation finance were really benevolent and not trying to profit maximize, I think is just, it's a fantasy and doesn't comport with reality. And one other point. On the plaintiff side, lawyers have been doing litigation finance among law firms forever. So it is very common for wealthier, well-capitalized plaintiffs' firms to enter into co-counsel arrangements with other plaintiffs' firms in which the well-capitalized firm funds the litigation, they pay for the experts, they pay for things, and then they get a return out of the fee at the end. It's the exact same thing. The only difference is that there it's lawyers using law firm money as opposed to funders using non-law firm money, which does not strike me as a distinction with a difference for purpose of most of the things we've heard this morning. The other benefit of litigation finance is it can be a way for new lawyers, marginalized lawyers, young lawyers to enter the plaintiff's bar. As we just talked about, the fees are always deferred in the contingent fee posture. And so if you can get litigation finance early, the lawyers can have some revenue, they can pay the bills, they can pay the rent, and they can operate and they can be good lawyers for their clients. And then the funder can get a return later on if the case is hit. Hopefully they'll hit. And if they don't, then the funder's out their money and the lawyer still gets to keep it. And so it's better off for the lawyers. Okay. So one of the other points we heard was about and I'm going to be a little scattered because I'm trying to catch as many of the points as I can. One of the things we heard about was non-meritorious cases and this concept that people are ginning up a lot of frivolous cases to put them into some kind of a portfolio on the theory, I guess, that if you have a bunch of garbage in the portfolio with a little bit of gold, somehow it all becomes gold. I have not encountered that at all. I'm not totally sure what that's about. Every case we've looked at and every case that I've heard about trying to be funded in the secondary, which does happen, the funders are really concerned about whether it's meritorious. Something like 5% of the cases that go out for funding, at least in our fund and most of the other ones I know, get funded, which means 95% don't. So the funder really, really cares about whether it's a meritorious case because the funder has got capital at risk, and if the case or the portfolio goes sideways, the lawyers or the plaintiffs keep the money, the funder is out, and so it's very important to not have non-meritorious cases. I think if we're worried about non-meritorious cases, that is a function of, basically the shotgun approach some contingency fee lawyers use, where they file a lot of things, hope a few hits, and all they're out is a little bit of time. I have not encountered that at all with funders, and it doesn't really make any sense to me based on how funders operate. Another objection you hear, you have heard, is that litigation finance is going to interfere with the attorney-client relationship. So I have a few things to say about that. The most important one, I think, is that, look, the defendants have a long-standing playbook they've built over decades to constrain a plaintiff's options. This is not a surprise. Most of you who have had large law firms in your courtrooms, I'm sure, have watched it play out. The defense playbook is you hire a big law firm with thousands of lawyers to bill thousands of hours to overwhelm the plaintiff with busy work and drive them into the ground before they can get to a merits resolution. And if you want to talk about the incentives to waste judicial resources, obviously the billable hour, at least obviously to me, is the #1 culprit in the American legal system for wasting judicial resources. Law firm partners and associates have a budget. That budget is based on hours, and they have to hit those hours. And so if they only have 2 litigations, my gosh darn it, they're going to need 2,000 hours a year for the 2 litigations. If they have 10, maybe they can spread the 2,000 hours across them. But you'll be shocked to hear that lawyers at a law firm that have to bill 2,000 hours usually find a way to do it with the cases they have. So this is what really makes me worried about the disclosure requirements. There is always a potential for harassment of your counterparty in litigation. That's why the discovery rules limit the litigants to obtaining discovery of only information relevant to a party's claims or defenses. If we open, for example, right now, we would be, I think, a little surprised if the defendant wanted to know how many mortgages the plaintiff has, what are the plaintiff's credit card bills, does the plaintiff have medical debt, does the plaintiff have student loans? And I think asking whether the plaintiff has somebody else who's helping fund the litigation is really nothing different than that. And it just has nothing to do with the merits in general. To that end, there's a really good opinion that I commend to all of your honors by Judge Stephanos Bibas, who's a Third Circuit judge, but was sitting by designation in the district court in Delaware. It's a case called Design with Friends versus Target. In that case, Target tried to take discovery of a litigation funder that was helping a really little company sue Target for or allegedly stealing, the case is ongoing, its intellectual property. Now, Judge Bibas, who's a really scholarly guy, he was a professor at Penn before he went on the Third Circuit, wrote a nice opinion where he explained that details about the funder's relationship with the company are totally irrelevant to whether Target stole intellectual property from Design with Friends, and that the funder's assessment of the case is protected work product. All right, so let's talk about why everyone is pushing for disclosure. I think it's actually pretty simple. The large companies know that disclosure will be an effective way to fight plaintiffs who are using litigation finance and to muddy the waters in litigation. I mean, let's get real. Everyone is, except for me, is here, well, not Judge Readler, is here because companies want to make it harder to use litigation finance. This is the chamber. They represent the companies. That's their job. I mean, there's nothing wrong with that, but that's why they're here. This is all about corporate power and efforts to avoid accountability. 124 companies signed a letter. Color me shocked that 124 companies signed a letter saying, make it harder to sue companies, please, because we don't want to have to spend money on litigation. Like, it's not actually that complicated to see what's going on here. And my fear is that as soon as we go down this road, defense counsel is going to, and this will be great for their budgets at the law firms, are going to devote more hours and more resources trying to take discovery against funders. They're going to drive up the cost of litigation. They're going to use the discovery process to tax plaintiffs and their counsel for using litigation finance, all as a merits resolution of the case slips further and further away into the distance. And I think that might all be worth it if funding had something to do with the merits, but it does not. So now, before I wrap up, I'll just quickly tick through the rationales I've heard for disclosure and explain why I don't think any of them actually holds water and why I don't think any of them merits the remedy that has been asked for, particularly given the costs that we've discussed. So the first one is this idea that the funders control litigation, that they have some sort of secret veto over things. Look, I totally agree. It would be a major problem if some secret funder somehow controlled the litigation or got to make the calls on settlement decisions or whatever. Every draft or final agreement I've ever seen fully disclaims control by the funder. It just does. And so this concern, I think, is basically contrived. We can talk about Cisco. Cisco is really complicated. It involved a huge amount of money going to Cisco, something like $150 million. Cisco breached its contract. I don't work at Burford. I don't know all the details. I just know that that is a very, that is a complex thing, and I'm not sure it really is appropriate for this panel. But in the mine run case, control is disclaimed. If we are really, really worried that somebody who's not in the room has secret control over the case, I have no problem with, and I'm sure most judges would have no problem with, a simple interrogatory to the plaintiff that says, does anyone other than you, the plaintiff, have decision authority of any kind over settlement or significant litigation decisions? It's a yes or no question. And if they say no, and it turns out there is some secret funder back there, then they've lied, and that's probably pretty good for the defendant when it comes to figuring out the rest of the case. So I just think the idea that we need to, rip open the hood of the car and take apart the whole engine to figure out if there's a different driver secretly controlling it, that's not a very good analogy, I just made it up. But you understand what I mean, is silly to me. I don't get it. It seems like overkill. Okay, so now we're talking about the resources of the parties, right? So I don't understand why the plaintiff having someone else who's helping fund that litigation is a critical part of the resources of the parties analysis. Should we ask whether the plaintiff has a wealthy grandmother who's decided to help fund the litigation? Should we go ask about their generous friends and their neighbors and who else might help? Or should we do intensive discovery into the plaintiff's law firm to figure out what their revenue is? Can they self-fund? I mean, it's ridiculous. And it's not hard to imagine that big law firms will see things to look at under every conceivable rock. By the way, the courts do not typically allow similar discovery into how the defendants fund their litigation. Should the plaintiff know whether the defense counsel's on a reverse contingent fee, whether they have a success fee, whether their fees are capped? Knowing whether their fees are capped would be really useful, because if their fees are capped and you, the plaintiff, drag out the litigation, boy, Kirkland & Ellis is going to get a lot less interested about 2 years in when they hit that fee cap and all of a sudden they're working for free. I don't mean to malign Kirkland. They're really good. They probably wouldn't cap their fees either. So are we really going to change this for everyone? Class actions. I don't understand the class action point at all. The lawyers can't give away the class's award. So in a class resolution, the judge says the class gets X, the lawyers get Y in fees. There's no mechanism for the lawyers to say, we're going to give away money that's not the fees to somebody else. I mean, that money goes to the class. The court supervises the whole thing. And I don't understand why the class would care what the lawyers do with the portion that is their fees. Right? Who do they care? If the lawyers might, give it back to a funder because they have an investment, they might go spend it all in Las Vegas. It doesn't matter. The class got the relief that the court approved, and the whole thing is completely on the up and up. And whatever happens with funders is happening downstream from the lawyers. So I don't understand that point either. This thing about witnesses are being paid, Guys, it's black letter law that you can ask a witness if they're being paid or if they have some economic interest in the litigation. This has been a question you can ask forever. If the lawyers are not asking it now, then they are incompetent. Certainly, if a witness who is testifying in the case is being paid, the lawyers can ask about that, and the witness will have to answer that question truthfully. This is not a litigation funding issue. It sounds more like a witness bribery issue, which is a problem that exists completely independently from litigation funding. This thing about judges who have a financial interest in the case, Judge Readler, I hope you have not invested in Burford Capital. I am not asking, that's up to you. I do not recommend that the judges in the room invest in litigation finance funds. I think that is probably not a good policy. But if you do, we are not taking investors at Vallecito Capital, but you could ask in camera easily whether the litigation fund that you invest in is involved in the case. And the lawyers will have to tell you. And then if it is, you can recuse. But the idea that all the judges are invested in the funders, and so we need to tell Target and Walmart and all these companies about whether there's funding, strikes me as a bit of a mismatch of a non-existent problem and a really broad remedy. We talked about this David versus Goliath thing. I'm not totally sure about what I don't really know what it means, but the idea that Goliath is going to use David's access to a loan in the trial to prove that David is actually also Goliath. He's not David. I don't know. I think it's still just David with the loan, and I'm not totally sure why we need to know that. And it actually seems quite unfair to say, well, we're a gigantic company and you're some guy who whatever got cancer or something. And so now we're going to make a big deal in front of the jury about the fact that somebody gave you a loan to hire lawyers to sue us over the cancer. It just doesn't seem, again, it seems like a mismatch. And then the last thing is this real party and interest point. Look, I totally agree. The defendant needs to negotiate with the right person across the negotiating table, and everyone should know who the real party and interest is. But that's just a repackaging of the control point. So yeah, totally. If there's some, guy behind the curtain who's controlling everything the plaintiff does, then that needs to be disclosed. That's not how funding works. And that's something that could be addressed through a simple interrogatory at the beginning. It says who makes the decisions. And if it's not the plaintiff, we need to know who that guy is or that woman is so we can go talk to them. And then finally, to the extent funding ever is relevant, and look, I don't pretend to know every permutation of every case that could ever happen. There might be cases where the funding really matters. In those situations, the current discovery rules are very broad. We normally allow pretty broad discovery, and they allow defendants to go investigate it. And so there's no need to put an extra thumb on the scale for big corporate defendants that says, oh no, this one thing, this is always discoverable. And I'll just close by talking quickly about insurance, because that's the analogy my friend drew, and it's one I hear a lot.
Very quickly.
Very quickly. Okay, am I over? Sorry. Yeah, sorry. All right, last point. In a nutshell, that's already an exception to the typically tight disclosure requirements. We don't normally allow plaintiffs to get into a corporation's cash reserve set aside for litigation loss, the fee structure of defense counsel, or whether the defendant is using third-party debt or equity to fund the litigation. The insurance thing's a narrow exception. Why do we allow the narrow exception? Because the insurance policy satisfies the judgment. And the plaintiff does need to know if there's going to be enough money at the end to satisfy the judgment so that the litigation is worth pursuing. On the other side, litigation finance is just money to litigate the case, which just sounds like another way of understanding the plaintiff's fee structure. Thank you, Judge. I'm sorry I went over.
No, thank you. That was terrific. It is the Law and Economics Center, so it's appropriate for us judges. You gave us both some legal advice and some investing advice.
Always happy to help.
Yes. Our last speaker is Rachelle Mortimer. Rachelle serves as a senior director at the U.S. Chamber of Commerce's Institute for Legal Reform. At ILR, she works to champion a legal system that promotes economic growth and opportunity. She's primarily responsible for legal reform advocacy efforts in state capitals throughout the eastern and midwestern portions of the country. Before joining ILR, I'm having trouble saying that, Rachelle worked in copyright law and policy, advising clients on intellectual property protections, as well as advocating for creators' intellectual property rights in Congress. I would be remiss not to emphasize that Rachelle holds a JD from the Antonin Scalia Law School at George Mason University. Rachelle.
Thank you, Judge Readler, and it's good to be here with everyone today, and thank you to the Law and Economics Center for hosting. So it's very nice to be back in this room. It's been a while since I've been here, but I look forward to, kind of talking a little bit more, and I'd like to be a little bit precise, I hope, in talking about this very complex issue. So I'm going to start out with talking a little bit about where we've come from on this. And as you've heard mentioned from the other panelists, litigation funding has been around for a long time, but the, form of this litigation funding and the different ways in which the litigation funding is, completed has grown and changed and, looks a lot different now than it did when this practice first started. So I think that it's important as we talk about these issues to kind of make sure that as we're talking about different aspects of this, that we're defining them clearly. So as, I think some on the panel have mentioned, there's a lot of what some people refer to as consumer funding, which is basically funding that is provided directly to a plaintiff, and that funding is often provided for things like personal costs, so things like covering the rent or covering medical expenses. You give it to the person to cover their needs as they wait for their settlement. Some of the other types of litigation financing that we're talking about here is really, litigation investment for profit and then nonprofit litigation. So, those are two different categories, I think, as we look at them, due to the fact that when you're investing in a case for a profit, it gives you different incentives than someone who is investing in a case for, because they believe in a certain cause. And I think that, that causes different conflicts of interest on each side, and it's, basically two separate conversations. And I think what most of us are, referring to today when we talk about litigation is litigation investment. So that's the for-profit investment in litigation, and the funder is putting money in expectations of getting a return on that investment when the litigation is finished. So throughout the years as this has grown, I think that, we have seen some of these developments also that have been mentioned, such as portfolio funding, which really wasn't seen, often before now, and we still don't really even know the full extent of portfolio funding, though we do know now, or we expect now, that it is the majority of litigation investment is in portfolios rather than in individual cases. The other thing that we've seen, I think more recently from litigation funding is, investment in things that aren't attorney's fees or expert fees, things like advertising or lead generation that is, part of the investing now that, wouldn't be considered investing in legal costs like you might expect from litigation investment, but is still an investment that is meant to, further the litigation and to collect these claims that, the professor has mentioned. And so I think, this issue might not have been on many of your radars, just a short time ago. And, you may have even come to this symposium this week and not known that third-party litigation funding was something that may be active in your courtrooms. And so this issue has really picked up a lot of steam in the past few years, I think because of a lot of these developments like the portfolio funding, and because, as there's more money that is put into these types of litigation, it's starting to become more and more common to see it both in, the common parlance of, the average everyday person. I think that that's still very low, but is starting to become more prominent. For example, and this is, a bit, it's from a UK example, but there has been a television show that was widely popular in the United Kingdom about a case from some postmasters who, due to a technology glitch, were subject to some very serious harms like criminal prosecution because they were accused of basically embezzling money from the post office where they worked. But the reason I mention this is because that show that was put out about this litigation was the first time I think that a lot of people have probably heard about litigation funding. And the episode where they talk about it is when the postmasters find out that they've won their case and that after the lawyers and the funders take their cut, they're only going to get 20% of the outcome of that litigation. So the reason I mention this is because, I just think that it's important to understand where we've come from, and also I think that it's great that this issue is kind of coming to a head now and, really starting to be talked about at panels like this and in shows like the Postmasters. And, I think that the momentum is because it's becoming a bigger and more prominent feature of our legal system and causing, the legal system to transform in ways that I think a lot of people want to make sure that they're being aware of and managing. So now that I've talked about somewhat where we've come from on litigation funding, I'd like to talk about where we are right now. And I think, some of this would have been talked about yesterday, but there are legislators that are looking at this issue. There are 5 states now that have passed legislation to manage litigation investment in some ways. Those all kind of vary, but they all have some form of disclosure or increased transparency, and also generally prohibitions on any control of the litigation by the litigation funder. And, I think that there are additional state-level legislation that has been introduced, some in states that you may work in. And I think that the federal level as well is looking at this legislatively. There has been legislation introduced, I think just yesterday actually, by Representative Issa of California. There was previously legislation introduced dealing with the foreign investment aspect of litigation funding, which I can get into a little bit more later. But those bills are still pending. And then more relevant to you all in this room maybe is some of the judicial efforts that are underway to look into learning more about litigation investment. And so at the federal level, we have the Civil Rules Advisory Committee that is, I think, in a few days going to consider, or they've been considering for a while, it's been pending, but at their next meeting, they're going to pick it back up again. They're considering a disclosure rule at the federal level. State courts some have put in place disclosure rules. I think it was mentioned earlier that the Northern District of California has a disclosure rule. A judge in the Northern District of Ohio has put in place a standing order. I think we've heard, maybe a lot about some of Judge Connolly's disclosure rule in Delaware. The District of New Jersey has put in place a local rule that requires disclosure of litigation funding. There are other courts that are currently reviewing rules suggestions, such as the Texas Supreme Court and the Arizona Alternative Business Structure Task Force. And Arizona is a bit of a unique situation because Arizona has allowed the non-lawyer ownership of law firms, and those are called alternative business structures. So they're specifically looking at the need for disclosure of third-party litigation funding in that context, and also looking at whether Arizona allowing non-lawyer ownership of law firms is causing sort of an issue where law firms are targeting Arizona as a place to open their law firms in order to get investors and have ownership of the law firm that is not non-lawyer ownership, but then also litigating in states around the country while they have their base and their investors in Arizona. So all of that is to say that, again, I think that this issue is gaining a lot of momentum, and that there are a lot of different aspects that, have encouraged folks to look more closely into the issue. And we've heard about a lot of them today. I think, looking back at Judge Connolly's order in Delaware, it has already provided us with a lot of information that we wouldn't have had without his disclosure order. And some of that is in the Nimitz case, which some of you may have heard about. But this was, small or, reportedly small, owners of patents suing again for patent. And what was found out, what prompted Judge Connolly to kind of pursue this investigation that was mentioned earlier, was that many of these, folks who were reportedly the owners of these patents had never talked to the attorney who was, representing them or allegedly representing them. They had never, they didn't know about the third-party litigation funding that was kind of pushing these patent claims forward. And we know from some other reported sources that, up to about 1/3 of litigation funding is in these patent cases. And so we, wouldn't have had as much information on how some of these patent claims can, be really pushed forward by a litigation funder and attorneys, and not so much by the individual purported owners of the patents. And again, I think another aspect that Judge Connolly's order has given us more information on is like I said, the foreign funding aspect. And this is a concern that, with the secrecy of litigation funding, foreign funders, foreign governments, or foreign, companies can be investing in litigation without any knowledge of the court or the defendants in the case. So in Judge Connolly's court, we found out because of his disclosures that a company called Purple Vine was funding litigation, patent litigation again, in Judge Connolly's court. And this patent litigation was against Samsung, and the reporters that reached out to Purple Vine, a Chinese-based company, were answered from a TCL email address. And some of you may be familiar with TCL. It's a Chinese electronics giant. So an electronics giant in China was using U.S. courts to sue an electronics giant in South Korea using the United States courts. And of course, I think the representative TCL said that they had nothing to do with, Purple Vine, that Purple Vine made their own investment decisions. But we found out later through some more litigation against Samsung that Purple Vine was actually the plaintiffs were being represented by a law firm named PV Law. They don't officially have a connection to Purple Vine, but they have represented Purple Vine or worked with Purple Vine while representing plaintiffs in multiple cases. And a former Samsung employee had actually stolen documents from Samsung and allegedly provided them both to their attorneys at PV Law and also to the litigation funder Purple Vine. So I think that, that illustrates some of the concerns that have been brought up about, proprietary information in these claims and other things that have been brought up by officials at DOJ and others about potential investment by foreign actors in our litigation center for, to profit off of, persecuting a competitor or, receiving some sort of proprietary information. So I think, the other aspect of these disclosures that we've seen often from judges is in the context that the professor mentioned with MDLs and class actions. Many judges have started asking counsel in those cases why, if they're using third-party litigation funding or if they plan to. And I think, this comes down to the fact that in a lot of these class and mass actions, the plaintiffs are often not there to represent themselves, which is why we do have some more oversight with those cases to protect those absent class members. And I think the issue is exacerbated by the third-party litigation funding, because when you have a plaintiff's attorney and a representative plaintiff that may be representing the whole class, and they're being influenced by a litigation funder that may be saying, oh, well, we need a higher return for this litigation, we need to move forward, or they don't want to continue moving forward, they are influencing the decisions of that leadership of that class or mass action, which could affect what the outcome is for the rest of the class. So I think that that's another one that judges have really been looking closely at, since the funding may be more prevalent in those in some instances. And then I just want to mention that, this is not this is still an ongoing issue. It's a future-focused issue. So Judge Connolly has continued to present at conferences and discuss how, it's bad for the litigation system to be treated like a casino or like putting bets on litigation. And I think that, the judiciary has a really important role in helping to, learn more about how litigation funding is affecting your courtrooms and also the legal system as a whole. The litigation investment space is not getting smaller, it's continuing to grow. And you probably heard yesterday from some of the panelists that there's about $15 billion in assets under management in the United States right now. And the investment is continually flowing into the United States. Litigation investment started overseas, but due to the fact that we have very open courts here and a very active litigation system, the investments are pouring into the United States now. And I think that it's important that as we attempt to learn more about this practice of investing in litigation, the judiciary, you all have a very important role in providing and, gaining information, not only for yourselves as you, manage the litigation in your courtroom and knowing who is in control of the litigation, and what the motives are of the party, and also ensuring that the plaintiff, is protected and maintains control over their case. But also for the public to know, what this, litigation investment, how it is transforming the litigation system. And also for legislators and others who are going to be looking at this issue and will need data to know what needs to be done outside of just the disclosure, whether it's a fiduciary duty, or, other protections that would need to be put in place to make sure that this, is really working for the judicial system and for the legal system and not against it. And so I think, just to address some of the, the issues with relevance, I think that those kind of, relevance to the case itself is not the point. It really has relevance to the procedure of the case. It may, in some instances, have relevance to the case itself in really kind of probably outlier circumstances, but most of the time it's going to be more of a procedural focus where, if there's, sanctions that need to be placed, who's paying for those? If there are, proportionality issues with discovery, if there, as was mentioned, some sort of David and Goliath type argument. So those are gonna be, procedural things that are important where, relevancy is not kind of the end goal of the disclosure of the litigation financing agreements. So I hope that kind of has clarified kind of what we're specifically talking about and, where this is kind of going. I think we see it as something that, the litigation financiers are not focused solely on small businesses or anything like that. They will fund a Fortune 100 company, as we've seen in cases that have been brought up on this panel. And, I think the other thing to consider is as litigation funding becomes more and more used, what happens when there's litigation funding on both sides? Is it just that, the risk that each side sees and the skin in the game that they have gets more diluted on each side? And then we just have, litigation that's an arms race or, just an investment vehicle that really doesn't have justice in mind. It's just being pushed forward by parties that are, looking for a return on investment instead of what the real purpose of the judicial system is, which is getting justice for the parties. Thanks.
Great, thank you. So we've heard a lot this morning. Maybe we can just go back to the start of the panel, Professor Steinitz, and if you have a minute or so of reaction to everything you've heard.
Yeah, thank you very much. Just three very quick points. One about control. So in most of the contracts that I've seen, and I've seen many that have language that explicitly disclaims control, there is economic control. And that's usually achieved in a couple of ways. One is that funders keep a right to stop funding in different situations. So that's called in economics the hold-up problem. It basically means that the funder can say, please do X or refrain from doing X, and if not, I have a contractual right to stop funding. And another mechanism is that funders get to install requests who are the lawyers who conduct the litigation, and those are lawyers that they have repeat play relationships with. So if there's one thing I hope you take away from today's panel is that the question of whether or not there's a provision that disclaims control is the starting point of an analysis of control, but it's by no means the end point. Another thing, a point I wanted to make is that obviously we have judge-made law in this country. Other countries don't have it, but we do. And so who gets to shape the law through the courts is the equivalent of lobbying. And so judges and the public have a right to know what kind of money and whose money is behind shaping precedent through the court system. And I know I had a third point, but very quickly. How do portfolios create incentive to bring non-meritorious cases? And I do want to emphasize that I certainly think that in investing in single cases, funders have the incentive and do a good job of vetting the cases so that they're meritorious cases, and that I think that there's a will to vet portfolios as well. I do think funders only want to invest in good cases in terms of what their motivations are. However, if there are enough good cases in a portfolio, adding additional cases means that there's just a bigger threat to defendants, and they have more of an incentive to settle. There are decades of economic literature on this issue with respect to mass and class actions and that critique of class action lawyers, and it's just the same critique with respect to funders. So I'll stop there.
Thank you. Alex, 1 minute.
Two thoughts. First of all, I think that some funders want you, the courts, to think that this has nothing to do with you. There is nothing to see here. This is a matter of bookkeeping, and there's no reason for you to walk down the hall to accounting to talk about this topic that is really unimportant to you. On the contrary, this topic has everything to do with how courts handle the idea that non-parties to litigation make control decisions and benefit directly from the operation of courts. How does our judiciary deal with that? Well, at common law, it was a tort and a crime to take an action in somebody else's name and to support somebody else's litigation that you were not a party to without being known to the court and the parties. Now, some states have started to rethink that, and maybe it deserves a little rethink, but that doesn't mean that we should wholesale abandon the idea that it is important for courts and parties, and I'll throw in the public since we're in the United States, to know what's happening in their courts and who's using it for what purpose. Let me give you an example that might be particularly relevant to the appellate judges in the audience. Amicus briefs. I mean, how do courts deal with the idea that a non-party wants to participate in some way and let their thoughts be known about a case? Well, they have to have disclosure. And with any amicus filing in district or appellate court, you automatically know the name of the amicus filer, their lawyer, which is filed on the brief, and there are rules for even more disclosure. Who wrote the brief? Who paid for the brief? Was it a party? Is the party a corporation? Does that corporation have a parent company? Et cetera. Well, why is this information important? It's important because courts and parties need to know when non-parties are trying to sway the court on something that is not in their, they don't have a direct interest in. Or in this case, they do. Those are the rules for people who don't have the direct interest, and third-party funders do. So anything that is important about the amicus disclosure is a fortiori more important to get from third-party funders.
Just 10
Now, the
seconds,
second
just 10
part,
seconds.
let me, very quickly,
Okay, 10
that
seconds.
the funders want you to believe is that third-party funding is the greatest thing since sliced bread. And maybe it is, I don't know. But implicit in this argument is they want you also to believe that if they told you who's slicing the bread, the whole thing would collapse and nobody would ever use it and the industry would go away and all these benefits would vanish. Well, why is that? Look, the attorney-client privilege exists even when you know who the attorney is and who the client is. There's no problem with the fact that you might know who the party is, who the funder is, and what they're doing in the case to say that the courts can't function with this whole business. They're asking you to change the culture and traditions of the courts. And for what reason? What is it that is so important for the courts to stand up and protect the secrecy of these agreements that couldn't possibly function if the court knew what they were doing?
Thank you. James?
I have 4 quick points in rebuttal, and I'll keep it to 1 minute, Your Honor. So first, look, I'm very glad that corporate America is worried about the legal system. I agree that the litigation finance would not collapse, but it's a tax. It's a tax. They make it more expensive. They make it harder. They want to come depose me. I would probably be a very bad deponent, and that's what this is all about. It's just about giving the corporate defendants more tools to fight off the plaintiffs' lawyers who are trying to hold them accountable. Let's not pretend it's about anything more complicated than that. I was really pleased to hear my my friend Rachelle say that relevance to the case itself is not the point. I totally agree. That was, I think, a very important thing to get on the record. If there's procedural relevancy in particular context, you have the discovery rules already. The court certainly has the authority to look into what's going on if it is actually relevant to whether David has an extra sling in his back pocket or Burford bought him the sling or whatever it is that the defendant wants to investigate. That's up to you. Professor Steinitz and then Alex also spoke about the public right to know who is shaping precedent or who is filing amicus briefs. Guys, the most important litigation funders in America that shape precedent and file amicus briefs are not Burford or me. They're the U.S. Chamber Litigation Center, the ACLU, and groups like that. I suspect that if we said that the public has a right to know which companies are funding which cases that the litigation center is doing, the litigation center would be very unhappy and would say they have a First Amendment right to not tell us that. So the idea that we're having some sort of disclosure in the world that my friends, well, not the professor, I don't know if she files amicus briefs, but in the world that the sort of C4s and C3s operate in is ludicrous. The amicus brief says it's paid for by the U.S. Chamber Litigation Center. The U.S. Chamber Litigation Center does not have revenue, so it is being paid for by somebody who is not the U.S. Chamber Litigation Center through donations to the Chamber Litigation Center. So if we're going to go there, we have to go there for everybody. It can't just be the people that want to hold companies accountable. It has to be everybody involved. And then the last thing I'll say,
10 seconds.
Perfect. Is the control thing. Look, I think we agree that there's not actual control ever. So now we're talking about economic control. Maybe we don't agree, but if there is control, you can ask that in an interrogatory and they can answer it. And if there is, you should absolutely go investigate what's going on. If we're talking about economic control because the funder can stop funding, I'm not sure why we think that's a bad thing. Like the funder is saying, I'm not going to continue funding a case that's going sideways. The plaintiff is better off because they got funding to that point than having gotten no funding at all. And that means the funder is going to stop providing capital for a case that's going south. That's not control, that's just prudent litigation. And the same thing a lawyer's allowed to do if a contingent fee case goes off the rails at some point in the district court. Thank you.
Thank you. Michelle, you have one point you want to, sorry, we got to the end.
No, that's fine. I will just make one point. I just want to emphasize, I think, the fact that, the litigation investors are not, an attorney representing a client. So I think there's a lot that we're looking at here where we think that maybe there are, ethical requirements for the litigation investment that would prevent them from taking control away from a client or, some other, aspect that would prevent them from taking control away, but that's not the case. I think we have acknowledged that there are some issues with contingency fees, but those are things that have kind of been, on everyone's mind, have been looked at very closely, and that's where the professional rules of conduct and responsibility come in to kind of make sure that those lawyers are putting their client's interests first above their pecuniary interest in the case. With litigation investors, you don't have that kind of ethical guard. Their interest is in the pecuniary outcome of the case, and that's where some of these conflicts of interest and the control come in. If you're putting millions of dollars into a case, you're obviously going to have a lot of stakes in that, and you can try as hard as you want to make sure that the interests are aligned, but as we saw with the Burford-Cisco thing, things change, there's an act of God, whatever it is, and the incentives of one of the parties, either the funder or the client or the lawyer, changes, and then once things are misaligned, that's often where some of these problems can come in. So it's good to know about these things in advance to make sure that, the parties have an opportunity to see if the funder is controlling, maybe not, settlement, but it might be that they control who is appointed as counsel, who is used as an expert, how the funds are used throughout the case, things like that. So I think that, control definitely is a thing. We've seen cases like the Burford-Cisco one and others where it's actual control of settlement. Burford-Cisco is not the only one, but we've also seen, other ones with economic control or kind of strategy control, things that, they control steps of the litigation. And I think, I really think that we'll see more of these going forward, and I hope that, this is an opportunity for us to learn more about the industry and to, make sure that we're going forward in a responsible way.
Thank you. Well, the timekeeper let you down. I apologize. No room for your questions, but I'm sure the panel will stick around. But this is a wonderful presentation. Please join me in thanking our president.
Thank you.